to mine in Brooklyn, for yielding time to me today, and I yield back the balance of my time.
I thank the distinguished gentlelady from New York for her leadership on this issue, for the progress that has already been made, and her continued commitment. The CBC, as I close, Mr. Speaker, will continue to take its role seriously as the conscience of the Congress, a voice for the voiceless, and the guardian of the integrity of the democratic process. And I'm just hopeful as we move forward that our friends on the other side of the aisle will end the obfuscation, end the obstruction, end the obsession with the Affordable Care Act, and we can find common ground to advance an agenda for the benefit of the American people. And I yield back the balance of my time.
The gentleman yields back. Under the Speaker's announced policy of January 3rd, 2013, the Chair recognizes the gentleman from California, Mr. Rohrabacher, until 10 p.m.
Thank you very much. Mr. Speaker, I would ask my colleagues, do we want to be known as the Congress that killed the U.S. patent system, a patent system which has served the American people well for 225 years? I ask America, are you listening? Congress is once again talking about reforming the patent system. Last patent reform bill, which passed last year, was the American Invents Act, and it just went into effect earlier this year, and patent lawyers and courts and inventors are still trying to figure out the implications of that change, of the change that that legislation made. And it was the most sweeping change in patent law in the history of our country. Yet, even before we are able to judge the effects of the America Invents Act, a new patent bill is being rammed through this House and through Congress. I wish I could focus simply on the bad provisions of this new bill, the Innovation Act. I like to think of it as the Anti-Innovation Act, H.R. 3309, which is expected to be on the floor later this week. But if the bill is bad, which we're talking about, the process being used to stifle debate and ram this down the congressional throats here on the floor is even worse. In the one Judiciary Committee hearing, witness after witness strongly recommended moving forward slowly and warned of unintended consequences. It only takes a few minutes to consider each provision of this bill to see that, although it may be aimed at a single thorn in the side of mega electronic companies, it will create much more pain in other industries, in higher education, and especially to individual inventors. In the rush to get H.R. 3309 onto the floor so quickly, it has not been even one single day between when this bill passed the Judiciary Committee, thus becoming available to members of the House once it passes the Judiciary Committee. And there's only not even been one single day of legislative business for members to consider and submit amendments to the Rules Committee for this important legislation. Not one single full day of legislative work done, and now this is being rammed down our throats. And, of course, the Thanksgiving holiday happened right after they passed it through the committee. The holiday was right in the middle of a very short timeline, which, of course, virtually guaranteed that all members and most of the staff would not be in Washington, D.C. Thus, they passed it right before we left town, and this schedule suggests what? It suggests that the fix was in. The clear message to little inventors: give thanks for your intellectual property rights because you may not have them this time next year. Well, this isn't just about rapid, it's also about covert. It seems that we have to pass this bill to find out what's in it. That hasn't worked well for America in the past, and it sure shouldn't be happening again on our watch. I'm calling on my friends and my colleagues who haven't had time to fully understand the implications of this legislation, and that means almost everybody in this body, And we're just back today from the holiday break. If you haven't had time to fully understand the implications of this legislation, join me in demanding a postponement of this vote until after the holiday season, which will give us all sufficient time to consult with our constituents, with experts, and to better understand this legislation and the implications it will have for industry, for American progress, for American inventors and innovators. Now to the content of this legislation. We are told this bill is aimed at the threat of so-called patent trolls. These so-called villainous trolls are patent holders, or they are companies who represent patent holders. They are engaged in defending the rights, their rights, given to them by ownership of that patent against the infringement of their patents by someone else. They own these patents. They are not just, and these are just as valid as any other patents granted by the Patent Office. But huge corporate infringers would have us believe that these patents are questionable, invalid, unworthy. They're unworthy of being a patent in the first place. Of course, these are the same corporations who have taken these patents and used them without paying the lawful fee that you would pay to someone who invented something that you are using. Well, this is not the case. They're not paying the inventor, and the patents that are being targeted by these multinational electronics firms as claiming that they're illegitimate, well, most of these were just the product of small inventors, and these small inventors quite often, because they're up against mega multinational corporations, are without a means to defend their rights if these corporations arrogantly decide to violate those patent rights. And what makes these vilified patents different from the good patents that are owned by these very same large corporations? Well, the so-called patent troll, it happens to be, most of the time, patent trolls are lawyers who take a case on to defend a little guy from theft. But that lawyer didn't invent it. That makes him bad because he's not working for a company, a big mega company that invents things. No, he's working for a little guy, or he has bought the rights the little man has so that he will get something out of his work. Well, being out for profit from technology, and from technology that someone did not he or she invent themselves, now that's really horrible. Doesn't that sound horrible? Well, no, it's not. We live in a society where people litigate to protect their rights, and there is nothing wrong and no we are being told that the patents in question that are going to be dealt with by this legislation, there's a hint that they're not legitimate patents. They're owned by patent trolls. Well, so much for calculated confusion. If the small inventor doesn't have the resources to enforce his or her patent, an individual or company can buy those rights, just like if they don't have the ability to farm, to plant on a farm. They can sell those rights, or they can create a partnership so that they can actually afford to actually protect themselves from being cheated out of their rightful compensation. I have spoken to independent inventors, conservative political organizations, and all of these people are very suspicious, of course, of these changes that are being put into place in terms of a person's right to litigate to protect their individual rights. Well, those people are also, there are people who are very suspicious of this legislation. The American Bar Association, industry groups, you got biotech and pharma. These people and universities throughout our country who are opposed or at least very concerned about what's going to happen by H.R. 3309, the so-called Innovation Act, which, as I say, should better be called the Anti-Innovation Act. Well, we know that this bill, if passed, will further, basically, further work against the interest, and it will further the disadvantages that the little guys have against deep-pocketed multinational corporations. And this is achieved in the guise, of course, of attacking patent trolls. See, they have used this word, demonized this word. I happen to have met a person, a man who was a big executive in a major corporation, a major electronics corporation, who was in the meeting with other electronics officials when they coined the phrase patent troll. They were doing it specifically to demonize these lawyers because they knew they couldn't go after the little inventor or the small inventor or the independent inventor. They couldn't go after him and demonize them, even though because they were stealing the patent rights from these individuals. So they'd go after the lawyer. And this person was saying they went around the room with their ideas. What's the most heinous word we can do to help blind the people about what's really going on? He had suggested patent pirate, but they decided on patent troll. Don't be blinded to the theft that's being justified here by demonizing a group of lawyers who are trying to defend small businessmen, basically small inventors. Proponents of this legislation are demonizing patent lawyers to draw attention away from the fact that they have stolen someone else's patent-protected technology. Now the big guys want to change the system so they can get away with the theft. That's what H.R. 3309 is all about, and that's why it should be called the Anti-Innovation Act. It is an aggressive attack on the ability of inventors to defend their ownership rights to the technology they have invented. It is not about frivolous lawsuits or trolls. That is a cynical cover that is being used and was created by the big guys as a license to steal from the little guys. The former Patent Office Director, Kapos, and other former directors of the Patent Office have made it clear that we should move slowly about this type of change and with great care when we're making such major changes in the patent law. This legislation is too broad, its implications are unclear, the effect unknowable. And that's what witnesses and other experts have indicated. They conclude, move forward with caution. So I would be asking my colleagues, vote against this bill. But if we can, let's ask our leadership, as I have pleaded with our leadership, postpone this so we can talk to our educators, talk to the universities, talk to the various employers in our district, talk to the various people who depend on technology and technology development in our country, rather than just go with a mega multinational electronics companies that are guilty of infringement cases as well as antitrust cases. That is not happening. Congress is being railroaded into passing this legislation right on top of the last legislation. Well, what's going on here? As I say, it's a heavy-handed attempt by mega multinational corporations to diminish the viability of America's patent system. It's been going on this way, and I've seen this for 25 years. Strong patent protection has been one of America's greatest assets. It's written into our Constitution. It's the thing that has given us the ability to have high wages, yet be competitive with other societies. It's protected the security of our country and our liberty. That's what strong patent protection has been to us. But according to the sponsors of H.R. 3309, this isn't really something about undermining the patent system. No, it's undermining the trolls, just by the fact that everything that they're doing has a major impact on the ability of lawful inventors to protect themselves against infringement, and it diminishes the patent protection that we have had traditionally in this country. Every provision. Well, what does it do? For the most part, this legislation will make it much more complicated, costly, and challenging to bring a lawsuit against an infringer. The little guy is going to cost him much more to protect his rights. Well, there you go. These people would like to restrict lawsuits that are totally legitimate to control a few people who have manipulated the system and thus are abusive lawsuits. Well, we face this all over. Lawyers, there are many lawyers who are engaged in abusive lawsuits, and they shouldn't be filing them, but they do. Does that mean that we are going to dramatically limit the rights of the American people to litigate when their rights have been violated by someone else, their property's been taken, or they have been abused and they deserve compensation? No, we're not going to limit those rights, but we will limit the rights of the small inventor and let these big mega corporations take what they want from what this person has invented and not give them compensation for it, rather than making it simpler, cheaper, and easier to defend against baseless accusations and, of infringement, and there are some baseless. And what we've done to reduce spurious lawsuits, all we need to do is strengthen the good guys. But this bill weakens the good guys. It weakens ordinary people who are actually contributing a great deal to our country, the independent inventors. In addition, under the claim of technical correction, this legislation proposes the removal of the patent system's only independent judicial review process. Section 145 of Title 35 in this legislation, if it is enacted, inventors who really believe they have not been treated well and treated fairly by the Patent Office. I mean, there may be people in the Patent Office who want to go to work for some major corporation if they decide a certain way. And what they have done, maybe it's not legal. Maybe these things happen in every society, and we need to have a review. In fact, since 1836, American inventors have had the right, if they feel the Patent Office has not dealt with them in a legal way, they have a right to seek independent judicial review. And that right was, by the way, that right was reaffirmed last year by the Supreme Court in Kappos versus Hyatt, which reaffirmed the importance of that review to maintaining the rights of our inventors. Well, this bill would eliminate that right. It just takes it away, something that has been the right of American inventors since 1836. I would suggest that I have a quote here that I'm submitting for the record from Mr. Lamar Smith, Chairman of the Science Committee. I would ask permission to insert it in the record at this point.
Without objection.
And in it, he goes into how important it is to have judicial review and that Americans understand how important that is, that not just bureaucrats, but they have a judicial review of what their government officials are doing and how important that is to our freedom. Well, I would say, yes, Mr. Smith, I agree. He's the chairman of my committee, the Science Committee. I am the vice chairman of the Science Committee. We disagree on this bill. But I will say that this is an important part of the bill, and H.R. 3309 would eliminate the ability for the court to review what these government officials are doing in their job if they hurt another individual. Mr. Smith thinks that's important when it comes to the environment. I think it's important for the environment and for protecting our inventors. This principle applies just as certainly, as I say, to patent review as it does to environmental regulations. Now the Patent Office officials have requested, of course, that they don't want to have that judicial review. Why is it? Because they say it's too burdensome. Never mind that very few really people have such claims, but we're going to eliminate that right and that option because it's inconvenient for our bureaucracy. That's absurd, and for that reason alone, this bill should be defeated. The legislation going before the House this week is consistent with a decades-long war being waged on America's independent inventors. Here are a few of the provisions of the bill. It will create more paperwork. When an inventor has to file an infringement claim, it dramatically increases the paperwork necessary to him to file the claim, and thus is not only more expensive, but increases the possibility that his claim will just be denied out of some technical mistake in the paperwork. The Innovation Act will switch us to a loser pay system. Now, of course, loser pay sounds pretty good. That means if you file a bad suit or something, or you lose a suit, the loser is going to pay the legal expenses for the winner. What does that do when you have little guy versus big guy, the small inventor versus the mega multi-billion-dollar international corporation? What it does is say, if a little guy sues the corporation and loses, that is nothing. Paying his legal expenses are absolutely nothing for this big corporation. But if he loses to the corporation, that corporation will have piled on legal expenses that will destroy the economic viability of that small inventor. It's no little guy versus big guy. In this case, making it loser pays is a big advantage to the big guy at the expense of the little guy. So the court, and what's unfortunate, this bill goes even further than that. This bill will allow the court to bring others into the case as plaintiffs if they have an interest in the patent. So if someone has invested in the person's patent, in the little guy's patent, if they've invested in it and they lose a lawsuit trying to enforce their rights to have a compensation for the use of what they've invented, well, if they lose that suit, the person who is invested with the little guy, he's going to be liable for this massive bill that these big companies are bound to pile on. So this basically loser pays system has some attraction, but in reality will be a disaster for people who are the little guy trying to enforce his rights. Basically, we have also in this bill, it would create new requirements that the patent holder must, once filing a claim for infringement, must provide information about all parties who have an interest in the patent, and thus what we have is a list that even the infringer will have. So this man, a small businessman, an inventor, will have all of his business dealings will then basically be made public, and his enemies will have that list to go after. This would have destroyed Thomas Edison. This would have destroyed our great inventors of the past. There are people who don't want to put themselves in public view in order to get behind new inventions. This means the total elimination of privacy in dealing with businesses, and of course we have another requirement in here that basically it's a reporting requirements for the little guy. We have the bureaucratic fees that are being forced on the little guy to maintain records that they now don't have to maintain. Thus you have a situation where the little guy has to have the expense of maintaining a bunch of records, and these things now are just yet another stumbling block. And when they, of course, when one of the other restrictions on the little guys, if he files a suit against the big guys, there's a thing called discovery. Well, they limit the right of everybody else can have discovery, but these little patent guys, these little inventors, if they're filing a suit against a major infringer, not only do you have to be so specific about what you want, we've replaced a system where there'll be one motion, we replaced it, which will require dozens of motions, each motion costing the little inventor tens of thousands of dollars of legal fees. This is, we're upping the cost and complication and legal ramifications of a man protecting, or a woman protecting, his or her patent that is a legitimate patent, all in the name of getting those terrible trolls. And the troll might not even be involved in this. There might not be any lawyer who's volunteering or is invested in this project. So what we've got, of course, is another thing where the person is there, and they call him a troll, but now the small business and education outreach part of this is it authorizes the patent office director to create a patent troll database. That means anybody who goes out to help these small inventors is going to be on a database. I guess you shouldn't really call that a database. Let's call that an enemies list, because that's probably what it would be used for. Oh, no, that list is going to be made of, here's the people you should stay away from. No, these aren't people guilty of crimes. These are people who are engaged in taking on powerful economic interests that are stealing the economic rights of our small inventors. And as I mentioned earlier, it also eliminates the judicial review that we've had since 1836 for our inventors. Is there anything that could be more of an attack on the well-being of America's inventors? This, as I say, is a consistent pattern that I've seen for 25 years for what we call globalists who are trying to take America's strong patent system and weaken it so that we will not have the advantage that we have had throughout the world. We have had in the beginning, these people wanted to take fundamental parts of our patent system so that patents, even before they were public, even before they would be issued to the inventor, that they would be published for the whole world to see. That's what these people have been trying to get away with. Year after year after year, they whittle away at the patent protection of our people because they want a global system that is run by international, multinational companies. And the people running those companies, you think they're loyal to the people of the United States of America? You think they have our interest in mind as compared to a small inventor who loves the freedom and liberty that our country offers and understands that in another country he won't have that same freedom? No, it's been the small inventor. It's been technological development that has given Americans the standard of living, the security, and the freedom that we have enjoyed. And now this body, we're having a bill rammed through our throats that's been rammed through the system. Why? Because they don't want us to fully understand the implications of this bill, H.R. 3309, the Innovation Act, which will kill small American inventors in this country. I would ask that our leadership consider postponing this so the American people will have a chance to get a hold of their congressman, their representative. So we will talk and find out what the real effect of H.R. 3309 will have. And I ask my colleagues in closing, do we want to be known as the Congress that killed the U.S. patent system, which has served the American people so well for 225 years? I yield back the balance of my time, Mr. Speaker.
Gentleman yields back. The chair would entertain a motion to adjourn.
I do move that we hereby adjourn.
The question is on the motion to adjourn. Those in favor say aye. Those opposed say no. The ayes have it. The motion is adopted. Accordingly, the House stands adjourned until 10 a.m. tomorrow for morning hour debate.
So the House is gavelled out, but members return tomorrow at 10 a.m. for morning hour speeches and noon for legislative work. This week, work on a measure that would exempt advisors of private equity funds from registering with the SEC as investment advisors, but only if they have low levels of borrowing debt. Also possible this week, consideration of legislation aimed at preventing patent lawsuit abuses. You can follow the House live here on C-SPAN when members return on Tuesday.